North Andover Police and Fire calls being recorded. Hello? Hello? Police Department. Hello? North Andover Police and Fire calls being recorded.
My fucking Chevy though.
North Andover Police and Fire lines recorded.
This is Justin again. Can you please bring the OIC?
Yes, sir. Just give me a moment, please.
Good morning. This is Lieutenant Whitaker.
Lieutenant Whitaker, this is Justin Elaine. I'm at 125 Phillips Brooks right now, retrieving my belongings.
Okay. Hello? North Andover Police and Fire calls being recorded.
Hey, this is Justin again. I'm just calling Lieutenant Whitaker back. I just missed his call, unfortunately.
Yeah,
My fucking Chevy though.
North Andover Police and Fire lines recorded.
This is Justin again. Can you please bring the OIC?
Yes, sir. Just give me a moment, please.
My fucking Chevy though.
North Andover Police and Fire lines recorded.
Good morning. This is Lieutenant Whitaker.
Lieutenant Whitaker, this is Justin Elaine. I'm at 125 Phillips Brooks right now, retrieving my belongings.
Okay. Hello? Hello, Justin? Justin, are you still there? Hello, Justin?
Say that again, sir.
Justin, are you still there?
I'm still there. It connected to my truck for some reason.
Oh, I thought it was my phone was messing up or something. Yeah, so you said that you were over on Phyllis Brooks gathering some belongings?
Yep. Grabbed my belongings. The alarm did go off. They had changed the locks. The alarm did go off. Her dad has he set the full system up. He has everything. He's going to know the alarms went off, and I have no doubt in my mind he's going to be driving down from New Hampshire to show up here.
Okay. Whereabouts from New Hampshire would he be coming from?
He's up in the not the Rochester. I forget exactly what town he's in. He's probably about 40 minutes away, 30 minutes away. I don't know if he's coming, but I have no doubt in my mind that man is going to come down with a vengeance.
Okay. I mean, do you think that
I called 2 times. My family should have never been in this position. I called 2 times, once yesterday, once today, and I'm asking for a detail down here for 2 hours. If that's something that you guys cannot do, I will gladly escalate the situation. This is ridiculous.
What do you mean by escalate the situation?
I will go to the media. I will do whatever I have to do to ensure my family's safety, my brother's safety here, and 2 firefighters that are here. If his family comes down, they are absolutely going to be doing something.
Okay.
And if you're saying there's no resources for this, it's insane.
If you need a detail, I can put a detail out.
I will not be paying for a detail given the circumstances of this. You can bring this to the chief. Please bring it to someone, because I am not paying a cent for this. This is ridiculous. Given the circumstances and the escalation of this situation, providing a detail and having it be your guys' idea is unbelievable.
We can provide a detail, but you're going to be charged for it.
I will not be charged for that. You know what? I am glad this is the 3rd time this is happening, because when something does happen at this location, it is going to be all on that department. Once again, this is unbelievable.
Justin, when he gets there, just call us and we'll send an officer over there to keep the peace.
That's not how it's going to go down, but thank you for your time.
North Andover Police and Fire, this line's recorded.
This is Justin Elaine. I need to speak to the OIC.
I'm sorry, who is this? Oh, who is this? Hello?
North Andover Police and Fire, being recorded.
Hi, I'm looking to speak with Lieutenant Whitaker.
He is actually tied up at the moment. Can I ask your name?
I had actually just spoken with him. This is Justin Alayan. I had just got off a phone call with him.
Hold on 1 second here.
Okay.
North Andover Police and Fire, being recorded.
Hey, this is Justin Alayan, off-duty firefighter. Can I speak to your OIC?
Hold on, sir.
Lieutenant Solis, can I help you?
Hi, this is Justin Alayan. I'm going to 125 Phillips Brooks to retrieve all of my belongings today with other members of the fire department. I had spoken to Sergeant Gerke yesterday about what would happen if she said I had full authorization to retrieve all of my belongings, and if her family shows up to call for a police officer. Given the intense nature of what has happened in that house and what her family has already been trying to do, I need to request a police officer is there at 9:30 when I show up.
Okay.
We're going to be there for 2 hours, and given the potential and the intense nature of what happened there, I don't know what has happened. I don't know what they're going to do, and I'm going to have to request that a police officer is there.
Okay, yeah, we have, can you hold on 1 second?
Yes, sir.
Thank you. Justin?
Yes.
Yeah, I'm told that the plan is if anybody does show up to give us a call, we'll be there immediately. We're very limited today on staff, but if there's any issue at all, we'll be there momentarily.
All right, I'm going to have it noted that if something does happen, I requested 2 times for a police officer to be there from the beginning. I want that noted because I will escalate this further because this is not right given the situation that occurred in that house and the potential for something else to happen. My family should have never been in that position in the first place. Now I'm requesting something that should be placed there, and you're telling me no several times. That right there is not right.
Justin, it's Katie. We spoke yesterday.
We did speak yesterday. We did speak yesterday. Given the intense nature of this situation and what could occur, I'm going to be there for 2 to 3 hours. I know what her father's capable of. I know what could happen.
But
Pressure media are there. I'm just telling you.
I understand the stressful situation, but what we spoke to yesterday was that we weren't going to prevent you from going in the house, but if something happened, you could call us right away and we'd be there. That was what we spoke.
Okay, no, we did speak about that, and after thinking about it again, I wanted to make my concerns noted 2 times. So if something does happen, if something does occur, this will be noted, and I have no problem escalating it further. I appreciate your time. Thank you, and have a good day.
What time are you heading over there?
I will be there at 9:30 with 5 or 6 other men. It's going to take a couple hours.
All right. Well, there was no formal request at a certain time, Justin. I understand.
I understand that. I went through Crystal as well. I asked Crystal. Crystal said she would ask as well. That I never coming back to me. This is a formal request. I called yesterday. You gave me this information. I'm calling again this morning, and I'm telling you that. You guys do last-minute details every single day. This is a last-minute detail. Yesterday would have been a detail that was not last-minute.
Would you like a detail?
I am not paying for a detail.
Okay. Right,
my family should have never been in that situation. My child and myself should have never happened. I will absolutely escalate whatever I have to do. If I'm saying that I don't feel comfortable and I don't want to put my brother again, my friends into a situation where something could occur, If you knew what happened, I don't know what her family would be capable of at this point. They've already filed negligence against me as the father when there has been nothing. I don't know what they're going to do. I don't know what they would be capable of. But if you want to wait and find out, that is on you. And I am glad this is a recorded line.
Okay.
So I will be there at 9:30. If you do not have someone there, all of my concerns have been noted. Thank you for your time and goodbye.
North Andover Police and Fire, been recorded.
Hey, this is Justin Land, off-duty firefighter. Can I speak to your OIC?
Hold on, sir.
Northern Police and Fire, this call is recorded.
Hi, this is Justin Land. I'm on the North Andover Fire Department. I am off duty right now. I do need to speak with the OIC.
Yes, sir. Hold on 1 second, please.
Hey, is this Justin?
Yes, this
Hey,
is.
it's Katie. How are you? I mean, that's a silly question, but I digress.
Yeah,
I do care.
No, I'm doing as well.
Thinking
as I
about
can be
you
right
guys.
now, and
Yeah. So what can I do for you,
Katie's
Justin?
good.
What's that?
I needed to discuss my options of retrieving all of my belongings from Phillips Brooks.
Oh, gotcha. I gotcha. Well, it's your house, so I'm assuming that you can make whatever arrangements if you just want us to because let's just say if this were, a scenario we deal with in any other case, with restraining orders, there's nothing barring you from returning to your own property except for your own safety. So I can't, we don't have any jurisdiction, and we don't even navigate about mutual property. So when we get restraining orders, people have to, commonly the defendant would ask to, it's different in this case because you may be in stow, from what I understand. But any property that's in there is between you, Kelsey, and civil courts. It doesn't have anything to do with us. We have no jurisdiction to say what can't be removed, what can be removed.
So am I able to go to the house with a bunch of fire buddies and remove my belongings?
Yes. We have no jurisdiction on that. I don't, are you in communication with her family and things? Like how?
No, I am in no communication with her family whatsoever.
Yeah. Do you know if they're at the house at all? That would be my only thing. If you wanted to go, if you feel like they're there, and I mean, it's your house. So truly, you can go in there anytime you please. And let's just say, hypothetically, they were there and they get all bent out of shape about that. What you could do is just call us for us to explain that to them.
So my only concern would be I know they're blaming me for a lot of this situation.
Yeah, I get it.
They
Yep.
are there
Yep.
for the potential retaliation or any of the sort.
Yeah. So you can play it however you want it to play it. I'm going to leave that up to you. One option would be to shoot them a text or anything, like, just so you know I'm going back to the house to pick up some belongings.
They would
say no, absolutely not.
I'm pretty sure they would show up.
Yeah. Okay. So what you may want to do is just go do what you got to do. I can't keep you from there, nor would I want to. It's your house as well. It's your property.
So it's technically the deed is in her name.
Sure. Sure. But you're
obviously a resident of that house.
Yes, you have legal standing in there as far as the civil courts are concerned. You have keys, you have access. I know you live there. We know you live there. We're not going to stand in your way from collecting your property. If you go and do your thing, and just if you get there and someone's there, we can, before you even go into the house, you could call us and, meet us over at the school parking lot area and be like, they're there right now. Can you send someone by to keep the peace? And we'd be happy to do that for you. We do that all the time. Especially if the roles are reversed. If you had been asked to leave the house, we do this all the time where, the person who has resided there has a legal right to grab things.
Yeah, I'm just going to get as many friends as I can and get out of there as fast as humanly possible.
Yeah, so if you end up being there, and either if they're there already, my suggestion would be to kind of head over to the parking lot of the school and we can break the ice, keep the peace, be like, hey, Justin has every right to grab his things, and you should cooperate with this because it's just why create more issues. I mean, it's not you live there too, with your baby and yourself for quite a bit of time, so we could break the ice first if you'd rather just do it that way and hope that they're not there.
Yeah.
And then if they show up while you're there, just try to keep cool heads and just call us and we'll send someone right over to keep the peace, just don't even mention anything and just be like, the police will come down and we'll sort this out. I'm not trying to create any, more difficulties for any of us, and let's just call the police. They'll come down and help us, No need to butt heads. No, sometimes things get very emotional and difficult. So, but we can diffuse it a little bit if we just say, hey, just let's all hang out for a minute, and we'll call the police to help us, tell us. And that's what we would say. And what we'd say to the family is, you know what, we're just trying to, he has a legal right to grab what he wants out of the house. He resided here. The son's in his custody, so you got to grab the baby's things, I'm sure. So, and if there is down the road, like any dispute on property, what we would tell her, like if she says, oh, my 50-inch TV's gone, he took it, we would just tell her that she'd have to take it up with probate court. Court.
Yeah, no, I just want my tools, my clothes.
Right.
I don't have any of my stuff, so.
Yeah, you have your weapons, I think. You have guns,
I do,
right?
Yep.
Yeah, you have all those.
I removed them all from the house the night prior.
Yeah, so that any property, we would just take a report from her and say, talk to the courts, because that's not our purview.
Okay, understood.
So if you're not going to give them if you're not going to give them a heads up, which is your right to, it's not my business to tell you what to do. That's not our jurisdiction because you don't have an order out against you, and you have legal standing in the house. Just call us if you happen to see their car there. And we'll meet you before and break the ice with them prior, and then we'll go from there. And if they show up, just call us. Just say, hey, I'm trying to get some property. Can you just send someone to keep the peace?
So even though I have a temporary restraining order right now, I am still allowed to go to that house?
Yeah, the restraining order is on her. Yeah, it's not keeping you from going back. Yeah. Mm-hmm.
Okay, understood. Thank you for your time, and I appreciate it.
Okay.
All right.
You got it, Justin. Call back if you need any help, okay? And
Okay,
I
will do.
do
Thank
feel
you.
for you, and I know this is terrible, but I'm a lot of us support you, and we're all, it's terrible what you're going through.
Yeah, no,
so.
it's
Nightmare. And I support you,
yeah.
and you're so kind to everybody. So anything you need, let me know. Okay.
Okay, thank you so much for your time. I really
you got
appreciate
it.
it.
Yep. Take care. Bye bye.
All right. Bye.
North Andover Police and Fire calls being recorded. Hello? Hello? Police Department. Hello?
My fucking Chevy though.
North Andover Police and Fire lines recorded.
This is Justin again. Can you please move the OIC?
Yes, sir. Just give me 1 minute, please.
Good morning. This is Lieutenant Whitaker.
Lieutenant Whitaker, this is Justin Alain. I'm at 125 Phillips Brooks right now, retrieving my belongings.
Okay. Hello? Hello, Justin? Justin, are you still there? Hello, Justin?
Say that again, sir.
Justin, are you still there?
I'm still there. It connected to my truck for some reason.
Oh, I thought it was my phone was messing up or something. So you said that you were over on Phyllis Brooks gathering some belongings?
Yep. Grabbed my belongings. The alarm did go off. They had changed the locks. The alarm did go off. Her dad has he set the full system up. He has everything. He's going to know the alarms went off, and I have no doubt in my mind he's going to be driving down from New Hampshire to show up here.
Okay. Whereabouts from New Hampshire would he be coming from?
He's up in the not the Rochester. I forget exactly what town he's in. He's probably about 40 minutes away, 30 minutes away. I don't know if he's coming, but I have no doubt in my mind that man is going to come down with a vengeance.
Okay. Do you think that
I called 2 times. My family should have never been in this position. I called 2 times, once yesterday, once today, and I'm asking for a detail down here for 2 hours. If that's something that you guys cannot do, I will gladly escalate the situation. This is ridiculous.
What do you mean by escalate the situation?
I will go to the media. I will do whatever I have to do to ensure my family's safety, my brother's safety here, and 2 firefighters that are here. If his family comes down, they are absolutely going to be doing something.
Okay.
And if you're saying there's no resources for this, it's insane.
If you need a detail, I can put a detail out.
I will not be paying for a detail given the circumstances of this. You can bring this to the chief. Please bring it to someone, because I am not paying a cent for this. This is ridiculous. Given the circumstances and the escalation of this situation, providing a detail and having it be your guys' idea is unbelievable.
We can provide a detail, but you're going to be charged for it.
I will not be charged for that. You know what? I am glad this is the 3rd time this is happening, because when something does happen at this location, it is going to be all on that department. Once again, This is unbelievable.
Justin, when he gets there, just call us and we'll send an officer over there to keep the peace.
That's not how it's going to go down, but thank you for your time.
North Andover Police and Fire, your call is being recorded.
Hey, this is Justin again. I'm just calling Lieutenant Whitaker back. I just missed his call, unfortunately.
Yeah, Justin, it's me.
Oh, okay. How you doing, sir? I had a couple quick questions for you again.
Yeah.
So she's messaging me telling me that she's planning on taking the baby up to the land in New Hampshire. Do I have any rights to make sure that she does not leave with that child?
At this point, I don't think we do. I've spoken to my superior.
Yeah.
Filled him in on everything that we talked about, and we don't really have the right to deny her child.
Do I have any rights as the father to obtain my child since she's had him for several nights now? Do I have any right to, hey, this is the custody, we're both parents here. It's almost my turn to have the kid for the night, so I can know that he's safe and I can go file these after?
Through the police department, no, we don't have that ability. The only way that you would be able to do that if you spoke directly to her and said, you know, I'd like some time with the baby, and if she agrees to that, great. But it sounds like she's
not
probably not going to be. Yeah.
I have my sister who's
Hey
had a quick question for you as well.
Yeah. I've seen a lot of this, and so I'm on the page. We need to get the baby out of her hands like now, or something really bad could happen. And I know you guys have talked a bit about this, but I am just wondering, is there any difference if she were to try to take the baby out of the state? Does that go against anything? Because that's what she's threatening with. Does the state matter at all? The state lines?
It really doesn't. It's her child.
It doesn't.
You know.
Okay.
Yeah.
One other question for you, because I think, we're talking about going to the courthouse. How do we, and especially because she is a police officer in this town and everyone talks, and I'm just wondering, if we go file this, how do we, because if she finds out that this is filed before it's being addressed, it's going to end really horribly. So how do we actually ensure, and I guess, do you know anything about that process? Would a police officer come with us or with Justin to the house to get the baby? If this is assuming the custody was ordered, that the restraining order and the custody were ordered, what does that look like? Because we're very worried she'd find out before it could actually take place.
Yeah, so if that's the case, then the way, if an order is granted, they will then email a copy of the order to us for service. So we would serve it and then enforce it. So it would be like, here's your restraining order. Per the order, custody of the child is awarded to Justin, in which case we would have to make arrangements, for him to come take the child.
So he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there.
Probably not. Guys... I mean, we should probably take care of that. It's okay if he wants to be close by, in order to take custody of the child quickly.
Yeah, right.
He could come if he's in town. We could then reach out to him and say, okay, she's been served. You can come pick up the child now.
Okay. One, just to, I guess, make sure that, because I know you guys will get notified if there is an emergency order put through. She's an officer, of course. What does she have access to see? I'm just, is there a way to flag this directly to, the trusted?
No, when it gets sent to the officer in charge. So nobody sees that except the officer in charge and anyone else who has access to that email, which she does not.
Okay, so that's reassuring. So I'm just trying to make sure there's no chance she could find out before this happens.
Did she catch wind while she was at the police station of anything occurring?
Nope.
No. Okay.
Nope. I didn't want to tip her off and give her the opportunity to do anything rash.
Thank you. All right, officer. I appreciate your time. Thank you.
Very good. Thank you.
Take care.
Bye-bye.
Okay.
North Andover Police and Fire, this line's recorded.
This is Justin Owen. I need to speak to the OIC.
I'm sorry, who is this? Who is this? Hello?
North Andover Police and Fire, your call is being recorded.
Hey, this is Justin again. I'm just calling Lieutenant Whitaker back. I just missed his call, unfortunately.
Yeah, Justin, it's me.
Oh, okay. How you doing, sir? I had a couple quick questions for you again.
Yeah.
So she's messaging me telling me that she's planning on taking the baby up to the land in New Hampshire. Do I have any rights to make sure that she does not leave with that child?
At this point, I don't think we do. I've spoken to my superior.
Yeah.
Filled him in on everything that we talked about, and we don't really have the right to deny her child.
Do I have any rights as the father to obtain my child since she's had him for several nights now? Do I have any right to, hey, this is the custody, we're both parents here. It's almost my turn to have the kid for the night, so I can know that he's safe and I can go file these after?
Through the police department, no, we don't have that ability. The only way that you would be able to do that if you spoke directly to her and said, I'd like some time with the baby. And if she agrees to that, great. But it sounds like she's
not
probably not going to be. Yeah.
I have my sister who
Hey
had a quick question for you as well.
Yeah. I've seen a lot of this. And so I'm on the page of we need to get the baby out of her hands like now, or something really bad could happen. And I know you guys have talked a bit about this, but I am just wondering, is there any difference if she were to try to take the baby out of the state? Does that go against anything? Because that's what she's threatening with. Does the state matter at all? The state lines?
It really doesn't. It's her child.
It doesn't. Okay.
Yeah.
One other question for you, because I think, we're talking about going to the courthouse. How do we, and especially because she is a police officer in this town and everyone talks, and I'm just wondering, if we go file this, how do we, because if she finds out that this is filed before it's being addressed, it's going to end really horribly. So how do we actually ensure, and I guess, do you know anything about that process? Would a police officer come with us or with Justin to the house to get the baby? If this is assuming the custody was ordered, that the restraining order and the custody were ordered, what does that look like? Because we're very worried she'd find out before it could actually take place.
Yeah, so if that's the case, then the way, if an order is granted, they will then email a copy of the order to us for service. So we would serve it and then enforce it. So it would be like, here's your restraining order, per the order, custody of the child is awarded to Justin, in which case we would have to make arrangements, for him to come take the child.
Okay, so he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there.
Probably
correct?
not.
So guys...
I mean, we should probably take care of that. It's okay if he wants to be close by, in order to take custody of the child quickly.
Yeah, right.
He could come if he's in town. We could then reach out to him and say, okay, she's been served. You can come pick up the child now.
Okay. One, just to, I guess, make sure, though, because I know you guys will get notified if there is an emergency order put through. She's an officer, of course. What does she have access to see? I'm just, is there a way to flag this directly to, the trusted?
No, when it gets sent to the officer in charge. So nobody sees that except the officer in charge and anyone else who has access to that email, which she does not.
Okay, so that's reassuring. So I'm just trying to make sure there's no chance she could find out before this happens.
Did she catch wind while she was at the police station of anything occurring?
Nope.
No. Okay.
Nope. I didn't want to tip her off and give her the opportunity to do anything rash.
Thank you. All right, officer. I appreciate your time. Thank you.
Very good. Thank you.
Take care.
Bye-bye.
Okay.
Good morning, squad. This is Kristi. If you don't know me from True Crime Squad, I will be doing a lot of the manning of our new process here over at True Crime Squad Trials, where we're going to be covering a lot more things, a lot more trials, just a lot more everything. I do want to just say here are some of the things we think are going to happen in today's hearing or potentially could happen. Final jury logistics, probably confirming juror questionnaire language, how voir dire is going to work, how many jurors they're going to seat initially, stuff like that. There may be some motions in limine. Some things that have been at issue are what attorneys may be saying in opening statements, whether there are any limits to referencing Kelsey's mental health, and whether prior alcohol allegations can be mentioned in front of jurors. Those are some issues. We may hear some things about witness boundaries, which witnesses are for sure appearing, whether there's going to be expert testimony, and if there are any rules to sequestration for the jury. There's also going to be a discussion possibly about the body cam and how it will be handled, if it's going to come through first responding officers, whether they're going to show the whole thing or if they're only going to show parts. There may also be some language restrictions on the prosecution, whether they can use words like victim, attack, or attempted shooting, if those are even going to be allowed to be said. And of course, hearings like this are a total crapshoot because the attorneys can be throwing things out in the moment as well. And so we don't 100% know what's going to happen, but those are some of the things that may be addressed. We have been listening. I thought we'd listen to this one more time while I'm here on the screen with you. This is a call that Justin Alain made to the Andover police. This is on the day of the service of the restraining order earlier in the day. So remember, the police know that's going to come. Justin knows it's coming. Justin's sister, who is also in this call, they all know that this RO is going to be served. Now, at the time that these calls are going on, Kelsey Fitzsimmons is actually there because she's an Andover police officer. And she was preparing to return from maternity leave. She was there taking a CPR course and supposed to be getting her radio back and like preparing to return to work. And she is none the wiser about any of what's going on here. But I want you to hear Justin Alain really, I think that he really lays out what his motives really were behind all of this. So let's listen to this call.
North Andover Police and Fire, been recorded.
Hey, this is Justin Alain, off-duty firefighter. Can I speak to your OIC?
Hold on, sir.
Someone.
North Andover Police and Fire calls being
There's so
recorded.
many of these.
Hey, this is Justin again. I'm just calling Lieutenant Whitaker back. I just missed his call, unfortunately.
Yeah, Justin, it's me.
Oh, okay. How you doing, sir? I had a
Good.
couple quick questions for you again.
Yeah.
So she's messaging me telling me that she's planning on taking the baby up to the land in New Hampshire. Do I have any rights to make sure that she does not leave with that child?
At this point, I don't think we do. I've spoken to my superior.
Yeah.
Filled him in on everything that we talked about, and we don't really have the right to deny her child.
Do I have any rights as the father to obtain my child since she's had him for several nights now? Do I have any right to, hey, this is the custody, we're both parents here. It's almost my turn to have the kid for the night, so I can know that he's safe and I can go file these after?
Through the police department, no, we don't have that ability. The only way that you would be able to do that if you spoke directly to her and said, I'd like some time with the baby. And if she agrees to that, great. But it sounds like she's
not
probably
gonna
not
allow
going to be. Yeah.
I have my sister who
Hey
had a
there.
quick question for you as well.
Yeah.
I've seen a lot of this, and so I'm on the page of we need to get the baby out of her hands like now, or something really bad could happen. And I know you guys have talked a bit about this, but I am just wondering, is there any difference if he were to try to take, or if she were to try to take the baby out of the state? Does that go against anything? Because that's what she's threatening with. Does the state matter at all? The state lines?
It really doesn't. It's her child.
It doesn't. Okay.
Yeah.
One other question for you, because I think, we're talking about going to the courthouse. How do we, and especially because she is a police officer in this town and everyone talks, and I'm just wondering, if we go file this, how do we, because if she finds out that this is filed before it's being addressed, it's going to end really horribly. So how do we actually ensure, and I guess, do you know anything about that process? Would a police officer come with us or with Justin to the house to get the baby? If this is assuming the custody was ordered, that the restraining order and the custody were ordered, what does that look like? Because we're very worried she'd find out before it could actually take place.
Yeah, so if that's the case, then the way, if an order is granted, they will then email a copy of the order to us for service. So we would serve it and then enforce it. So it would be like, here's your restraining order. Per the order, custody of the child is awarded to Justin, in which case we would have to make arrangements, for him to come take the child.
Okay, so he would not be there when you're presenting that. I mean, this might be an obvious question, I guess, because if he has the restraining order, he shouldn't be there.
Probably
correct?
not.
So you
I mean, we should probably take care of that. It's okay if he wants to be close by, in order to take custody of the child quickly.
Yeah, right.
He could come if he's in town. We could then reach out to him and say, okay, she's been served. You can come pick up the child now.
Okay. One, just to, I guess, make sure, though, because I know you guys will get notified if there is an emergency order put through. She's an officer, of course. What does she have access to see? I'm just, is there a way to flag this directly to, the trusted?
No, when it gets sent to the officer in charge. So nobody sees that except the officer in charge and anyone else who has access to that email, which she does not.
Okay, so that's reassuring. So I'm just trying to make sure there's no chance she could find out before this happens.
Did she catch wind while she was at the police station of anything occurring?
Nope.
No. Okay.
Nope. I didn't want to tip her off and give her the opportunity to do anything rash.
Thank you. All right, officer. I appreciate your time. Thank you.
Very good. Thank you.
Take care.
Bye-bye.
Okay.
No panic, no fear, no actual expressions of worry about safety. This was about custody. That's what this is. This is about custody. This was set up. There's a lot we don't know about what was said to Justin because we only have Justin's word at this point. Now, in the trial next week, we will likely see their digital communications, or at least some of them. I'm hoping that that's going to be the case because we really need to see really what was Kelsey saying and doing, what was she threatening? Because when you look at all of this, there's one person giving all the information. And did that person sound panicked and afraid? I didn't think he did. All he wanted to know was about custody and his sister wanting to know about custody. So I want to say very much thank you to YouTuber Broken Baker, who got these calls and released them for the first time last night. And thank you so much for sharing them. We appreciate that very much. We're little, just like lots of us are, and we only have so many capabilities. And so we always appreciate it when people are willing to share information. That call tells me who Justin is. And it also tells me what his motivations are. This wasn't about safety. Not at all. So it looks to me like the pool camera has gone live. So I'm going to pull myself off so I can pop that up for you. And here pretty soon, we're going to hear what this hearing is about. Please know that the audio is not great in this courtroom, and I'll have us turned up as high as I can go. You're going to still need to turn your audio up as well.
folks getting ready to come out. All right, please. Court now open. Let me see.
Good morning, Your Honor.
Good morning.
March 18th, 2026, Courtroom 4, Lawrence, Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a trial readiness conference. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Cooper, Associate on behalf of the Commonwealth.
Good morning.
Good morning, Your Honor. Marina Morgan.
Good morning.
Good morning, Your Honor. Timothy Brady on behalf of Kelsey Fitzsimmons.
Good morning, Your Honor. Martha Copley on behalf of Kelsey Fitzsimmons.
Good morning. Good morning, Mr. Fitzsimmons. You folks can have a seat.
And if I may, Judge, I have Ms. Healy with me, so she stays at counsel.
Yeah. I'm sorry. Her name again?
Ms. Healy, Courtney Healy, our paralegal.
Okay. Yeah, that's fine.
Thank you so much.
Okay. So we're on to really on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions. If you don't mind, I think these are fairly quick. So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror?
Yes.
Okay.
Judge, on that point, I don't want to waste a lot of the court's time. So just a suggestion is, could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay. I actually, that's one, you're ahead of me on my agenda because I was going to, let me just skip to that item, right, what you're speaking about. So what I was going to say, mention to you is that I believe at the last hearing you mentioned, Mr. Bradle, the possibility of Ms. Fitzsimmons waiving her right to a jury trial.
Yes.
And what I was going to say to you, and we'll give you some time, we'll take a break and give you some time to talk about it, but what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that even today. So
Exactly. We were going to have to take like 5 minutes and then.
No, we'll when we get to that point, you'll take as much time as you need. All right, a couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the 2nd floor, just to accommodate more audience and media members than we can fit in this courtroom, because as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Ruane. If the logistics cannot be overcome, then they can't be overcome. But at least that would be my preference, is to have a bigger courtroom than a larger courtroom than is here. All right, so that's that. And also, I will need if there's going to be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline. I'm assuming, is he still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zeidel.
Okay, all right, but, so would his, well, we'll get to it later. I'll also need, when and if we get to it, I need an address for Charles DeChara. Is that Commonwealth's witness or the?
No, it's the defense put him on there, but I'm working on that actually.
You're working on the address?
Yeah.
But it's a defense witness?
It was an independent investigation that was done by the North Andover police, and they created a report.
Oh.
I wasn't going to call him. He put him on the witness list. But I think I probably have better quote-unquote connections to get an address. So.
Yeah, just the town or the name of the business or something sooner than later. All right, so those were the only two items that I missed. And by the way, I did take out Ms. Fitzsimmons as being listed as a witness. So you're going to actually see on the next version that in order to save me having to renumber, I just put number 20 intentionally omitted. There's no reason to, and I know why you did it, both sides did it, but there's no reason to put Ms. Fitzsimmons. There's going to be plenty of questions about knowledge about Ms. Fitzsimmons and the case that her name won't be necessary on there. A couple other questions. One is on the scram device. Is that probation?
Yes.
Oh,
Yes.
hi, how are you?
Good.
Do you mind just stating your name for the record?
Yes, Your Honor, Probation Officer Tony Kidder.
Okay, and Officer Kidder, well, everyone, let me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a scram device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the scram earlier this morning, and I was going to contact electronic monitoring to make sure that it did not go off during the time that she was in the courthouse.
Okay. All right, I don't know what I don't know, and all I know about the scram device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you folks are out in front of this, but let's just make sure that it's not visible to jurors and that she isn't seen lugging it around or throwing into it in the courthouse. It's still a small courthouse, right? So if probation can do something to shut it off during the court proceedings, that would be great. Actually, better yet, during the time when Ms. Fitzsimmons will be near or in this building, and again, near even coming from parking, I just don't want to take a chance that a juror is going to, a potential juror is going to see her blowing into the screen.
Yes, Your Honor, I will make sure.
All right. All right, and then last thing is, so I'm already thinking about jury instructions, whether it's jury instructions or whether it's instructions to myself. And so there's two theories of assault, right? Or two ways of assault can be committed. An attempted battery, a threatened battery. Is this one, the other, or both? Or what is
Both.
Both. Just that's all I wanted to know whether I needed to. Okay. So really, I don't have anything else. There is Commonwealth filed a motion. So is that something that you want to do before we break? Does that make sense?
Yeah, the Commonwealth filed a motion to eliminate on Friday, I believe, or over the weekend, I'm sorry. The Commonwealth filed a motion to eliminate seeking to admit a number of text messages between the defendant and her ex-fiance, Mr. O'Layan. The text messages that we received to introduce span the day of the shooting, so just the day of.
I'm sorry, just let me interrupt, all right? So just setting it up for the record. So you're referring to paper 82, which is the Commonwealth's motion to eliminate to admit the defendant's text messages from the day of the assault. I did have some trouble reading them, but then I was given a better copy. But let me just ask, just yes or no, Mr. Bradle. Is there an objection to the motion?
There is, Your Honor.
Okay, all right, so now I'll hear you. Thank you.
So the Commonwealth suggests that the one thing that I think everyone can agree upon in this case is that the defendant's state of mind on June 30th, 2025 is the most relevant issue before the jury. And what more insight into the defendant's state of mind on the question can we get than her text messages with Mr. Elaine? I would suggest the Commonwealth is not seeking to do it over the weekend, over a period of time, but literally it is from the morning of June 30th through the afternoon, approximately sometime after 2 o'clock on June 30th. I would suggest that generally they're not particularly prejudicial, but they are relevant because they show that she is angry, upset, at times despondent, and clearly having a conflict with Mr. Olayan, and this is prior to the service of the restraining order by the North Andover police.
So your theory is they show what? Anger? What else?
They show her state of mind. And
No, I know that, but you gave me a laundry list of what state of mind you say can be gleaned from these.
From the Commonwealth perspective, she's angry at Mr. Olayan for not. Mr. Olayan has clearly is not at the house, has separated from her for a period of time, and she is angry and is trying to get him to come back to the house and trying to reconcile. So I would suggest that that is consistent with the Commonwealth theory that this shooting happened when the defendant heard Mr. Olayan.
Shooting happened.
The defendant raising her gun towards Patrick Noonan, and Patrick Noonan, in response, shooting the defendant happened at the time when Mr. Olayan was in the house.
Okay, so I'm sorry, are you saying that it's the Commonwealth's theory that Ms. Fitzsimmons heard Mr. Olayan in the house and then reacted to it, or?
That is one of the Commonwealth theories, yes. And I think the testimony would be something to the effect of the defendant said, keep him away from me.
Like in this exchange in the bedroom or near the bedroom or whatever?
Yes.
All right. I'm sorry, anything else?
No, I would just suggest that it's certainly more probative than prejudicial, and you just look at the text, there's nothing particularly outrageous in the text, but it does go to show her state of mind.
So, and how would these be admitted? They'd be admitted in this format?
Yes.
Like just, and how are they, how did the Commonwealth obtain these?
The Commonwealth prepped Mr. Olayan on Friday, and he provided them to the Commonwealth on Friday. So they'll be provided, they'll be authenticated through Mr. Olayan. And he would explain that he received them on his phone, and that this is a fair and accurate depiction of the screenshots he took from his phone of the text messages he had that day with the defendant.
And is this all of the text messages that they exchanged on that day, or is this a portion of them?
No, that is from that day, that is all.
All right, and the other thing that if we can just flag it and we'll circle back, is that I provisionally impounded, so I was out on Monday when this was filed, I believe, and I provisionally impounded the motion and the exhibit being text messages because I saw that Mr. Brado had requested it in an email or something. So I just want to, because it's provisional, I want to discuss how we address that. All right, and all right, so let me hear from Mr. Brado.
Thank you very much. Judge, so evidence has to have a rational tendency to prove a proposition in the case for relevancy, and it's not a rational connection to say that because Kelsey was supposedly mad at Justin on this day, that she's going to shoot her colleague from North Andover. It's like if I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on, I'm not going to do anything bad to the law girls because I'm mad at Charlie.
You must be the law girl. Okay. I am not on social media or any of that. So
You know,
don't assume I know who the folks are, but welcome. And you referred to another member of the media?
Yes, this is the law girls. They have their own blog. And it's just a rational thing. I mean, it's just, this just opens the door to the Justin stuff that is completely irrelevant to whether or not she assaulted Noonan in the bedroom when it was just the two of them. There's no relevance to it, to this charge. And there is prejudice, there is unfair prejudice to show that she's in a fight with her boyfriend. Nobody wants to be judged on that, Proposition A, when Proposition B is completely different, that we're here for trial on. So I just don't see the connection. Her state of mind about Justin is not her state of mind about Noonan. And there's just no possible rational tendency in terms of relevance that because she's mad at some totally different guy, that she's going to hurt her colleague and friend from work.
Well, here's the thing, perhaps I need to do a analysis under Rule 403, but I mean, it's relevant in the sense that the Commonwealth has to prove intent. It is a general intent, and it's also relevant because I think that Ms. Fitzsimmons has put her state of mind somewhat at issue because there's information, at least that I've heard, that that if she had the gun, she didn't point it at the officer, she pointed it at herself because of her mental state. So wouldn't this be evidence, again, just not for the truth, but for just to show her her mental state at the time of the incident?
So my strategy on that, and I'm happy to share it, is just that there's enough from the content of the restraining order that without having to open the door to mini trials about who was right between her and Justin and what are they fighting about and what's going on and what are the details of that. She just received a restraining order that said, as I said the other day, I won't go into it again, all the things that order implied were horrible, tragic, and awful. And that prompted her to have a sad, brief moment of intent to self-harm. And thankfully it didn't happen.
Let me say this. I've read these text messages, and I arguably thought that they helped you, frankly, because
sure.
I know that the Commonwealth sees anger in them, and yeah, I think it could show that, but
I agree.
But they also arguably show. It's what they don't discuss, I guess. I'll just leave it at that.
And that's my point, Judge, is that it's opening doors. It's like opening more doors about this when we're not intending on opening that door. And, I don't want to have that thing where, oh, well, this helps us, but then that might hurt us, and then this might help us, and then we're having a mini trial about Justin versus Kelsey.
But Mr. Brado, with all due respect, you folks put Mr. Allen front and center. Maybe you changed your mind about that. It sounds like maybe in the last year and a half you have, which you have a right to do that, obviously, but he's been pretty prominent, and their relationship has been pretty prominent from the defense's perspective, from what I've heard, right, and seen.
So if I can speak to that one, I don't need to talk about it.
No, go ahead.
Sorry. So Judge, we have to play both sides of that street because the government is pushing that. The government wanted to put, you saw that prior motion limited where they had these 4 things that are like, this is judgment day for Kelsey's entire life. The government wanted to open this case up to Justin and Kelsey and what happened in Maine and all this other stuff, and I think the government's backed off of that, but the government started that fight and I have to match it. I have to be ready if, out of an abundance of caution, if the government was going to go down that road, I got to be ready. So that's, the Justin stuff has to be vetted and I have to be ready if he's called and if he is a witness. You know, I have to be ready on both sides. My preference is that we have an economic trial here where, you know, the issue is Kelsey gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides. You know?
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that. But there's also an absence of any concern for her mental well-being by Mr. A. Allen. Really any any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time, which would so I guess that's part of the analysis of when I'm doing the 403 analysis is on the prejudice to the defendant. I'm not sure that I see a lot, but I can tell you this is that there is one passage in here that I thought I saw that where he said something about her allegedly hitting him or something, and
It's on the first page, Your Honor, the fourth bubble on the right.
So I give you a proffer on that, and so I appreciate what you're saying, Judge, about on its face, the general gist of those text messages would help in the sense of the distraught mindset. However, if that's where it sits, I can live with that in terms of but we'll talk about the hitting thing. But I'm looking at this like, I feel like the government's going to try to say that this opens more doors. And I don't want to go down this road of like going down, you know, Justin versus Kelsey and everything in Kelsey's past going back to two other ex-boyfriends. Like, that's where I want to guard against.
Commonwealth said 2 hearings ago, this is a simple case. You said at last hearing, and it will be a simple case, but it's still simple in the sense of what happened in the bedroom.
Right.
And it seems to me that what Ms. Fitzsimmons was thinking at the time is absolutely relevant, and then her state of mind in the hours leading up to it would be relevant too. And again, let me say this. I'm making an observation about what I say that they could arguably help the defense or hurt the Commonwealth, but that's only because, again, when I'm weighing the potential prejudice to the defendant and the probative value, that's all I'm really getting at under 403. So
Judge, if I could just invite the court to just focus on that one bubble about the hitting in terms of the 403. And that's really all I'd be concerned about. So there's more to the story, of course.
All right, so let me just, in Commonwealth, what would you say if that was redacted? So that bubble and just.
I just think the first sentence of that would be fine to redact, but I do think that the second sentence is not about what you need anymore. We need to be the best parents possible, and I cannot do that in the house at this time. I think that's all.
So, Mr. Brady, I don't know if you've heard that. So the Commonwealth is suggesting that. All right. So let me just back up. So my ruling is that the probative value of these, generally speaking, of the proposed exhibit outweighs any, really almost any potential prejudice to the defendant, except that the devil is in the details as to some of the content, and that one of those items being this particular passage where Mr. A. Allen is alleging that Ms. Fitzsimmons struck him in the face, even though she denies it right there in the response. So the Commonwealth is suggesting we simply just redact the first 2 sentences of the bubble of Mr. Elane's text about that. So that would, and the rest of that would come in starting with, it is not about what you need anymore?
Yes, sir.
Okay. And if you folks remind me at the time that I can tell the jury that it's common that things are redacted or struck from items just in case it's somehow visible that, in other words, if the jurors can glean that something's been removed, I'm happy at the request of either side to tell them why, which is basically out of the rule that wasn't even missing.
And Judge, also while we're on these, I would waive the request for impoundment.
Okay, waive the request for impoundment.
Correct.
So let's talk about impoundment. What's the Commonwealth? I'm just concerned about jurors just knowing, but I don't know.
Your Honor, this is, I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public already.
Okay, all right, so both sides say it shouldn't be impounded, so I'm gonna vacate the, and I'll do this, Mr. Brain, in an endorsement, but I'll vacate the provisional impoundment of that. What I'd like to do is this Commonwealth, so I have two versions, one's a vertical, and one's a horizontal. Is that right? Is that the way to explain it?
Yes,
So
I think the first version was too small really to be.
Yeah. So can we just give this back to you, and then you can shred it, and this will be this landscape, right? That's the landscape? Okay.
And that's exhibit one to
The landscape will be the official exhibit. It will, and it can be docketed in the normal course, public mid, sorry, docketed to the public docket. All right. And I'll have to also endorse, I will endorse it that I'm allowing it subject to that revision, so. Just, all right. And, all right, so do you folks want to take a break for a few moments? Yeah. Okay, all right, we'll do that. Just let Mr. Ruiz know. And you folks are.
All rise, please.
Thank you very much.
Yeah. Okay.
Course is a brief recess.
So, she's on the thank you. And I have spoken with her. Thank you. Okay. I don't know. I'm just giving you what I got, okay? So that's why, that's who that is. Okay. Michael, you got a supplemental witness list? Okay. Oh, I see. And this should be scanned? This should be scanned? Yes, yep. Thank you.
Oh, yeah, no problem. I figured it was gonna be a problem, so I'm glad I addressed this one.
Appreciate it. Oh, geez.
That's great.
Hey. Yeah. Thank you, Chief. I'm sure they know, right now. Yeah, that they're being recorded. And it was all written. Yeah, it was. That's the fact. Messed up. Looking at that earlier.
back on record on the matter of Commonwealth versus Kelsey Fitzsimmons. All counsel and the defendant are present.
Okay. Mr. Bradel?
Thank you, Your Honor. We filed two things, Judge. We filed a waiver of the right to a jury trial. And Attorney Coakley and Ms. Fitzsimmons are prepared to engage in a colloquy with you on that.
Okay.
And then the second thing we did file was a supplemental witness list that I explained to my brother a little bit, some additional names. I would say most of it is probably abundance of caution stuff that probably they won't be called. There's one name on there that did warrant some explanation for counsel at the Commonwealth, which I gave them, and I don't expect it to really add much to the trial.
All right, so let's table that, but I do want to, if the Commonwealth wants to be heard on these additional witnesses, absolutely.
No, I just, if I may put something on the record.
Sure.
As far as the jury waiver goes.
Well, before you do that, I was going to ask, all right, so we have a waiver. I was going to ask whether the Commonwealth takes a position, so you may.
My only position, well, I have no reservations with your ability to be fair and impartial in this case. In an abundance of caution, I wanted to create a record. At some point, I don't think it was last hearing or one of the press conferences that defense gave outside, a person asked about you, and Attorney Bradel told them and the world, I guess, that he worked together in the DA's office some time ago. And so I think there's a perception out there, for whatever it is, that the defendant had put out there. Like I said, I have no reservations as your ability to be fair and impartial, but I think I needed to create a record about that.
No, that's a very good point. So I don't, let me say this. I said before when I was joking with our media representatives, I don't pay attention to social media. I'm not on social media purposely. I don't read or listen to or watch or whatever media accounts of what happens in cases that I preside over or that I potentially could be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at sidebar. All right, so I'll just state for the record that Mr. Bradel and I, so we worked together, well, Mr. Bradel and I were in the same starting class of new assistant DAs in January of '95. I have Mr. Bradel, I have a picture of all of us, including Mr. Hagan, Judge Hagan, who, like me back then, had a lot more hair. So Mr. Bradel and I were in that class, starting class together. My memory is that I was assigned ultimately after the class. I think we met for a couple of weeks. We were a training class. I was then assigned to Roxbury District Court and Mr. Bradel to Dorchester District Court. And so that was '95. I left the DA's office in 2001, and at that time I was the chief of the domestic violence unit, which was a superior court unit. So Mr. Bradel, you can correct me, I don't think that we ever worked together in the sense of worked in the same courthouse, worked on the same trial team. I'm not sure that you and I ever even had a beer together back then.
I agree, Judge. I don't recall one, and I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where we always had a respectful cordiality at work, but nothing past that. And I've appeared in front of Judge Deacon, and never been a problem. And I left the office in '06, Your Honor, so I was there for 5 more years after you. I haven't seen you in probably over a decade, and I think the comment that Commonwealth Counsel was referring to, I recall it as just sort of a generic comment that I thought your rulings were fair, and that we appreciated the rulings, that I'd known you a long time, something to that effect.
Yeah, I don't think that Mr. Gubitosi was objecting. You just want to make sure that this trial, I've always strived that all of proceedings, whether it's this case or other cases, that there's a level of transparency. And I think Mr. Gubitosi's point is well taken. So I think I've described on the record what the nature of our relationship was. I'm not, again, I can't say that we weren't friendly, but it seemed like I was maybe you're the crew of people that you more gravitated to were from the Dorchester District Court. I was in the Roxbury District Court. But I'll also say this, is that for complete transparency, I know I had a murder trial years ago with Mr. Gubitosi. I found Archangel Morales, I don't know if you remember that, and I found working against you was you to be a really good prosecutor and really fair, and I respected you. I continue to respect you. That's what I was referring to at sidebar. And you know what? I probably spent I'm.
No, I was going to say maybe I'm not that memorable because we did 3 murders.
We did?
Yes.
Who else?
I can't remember the names. One was with Ms. Roman in front of Judge Lowy in Salem.
Oh wait, all right. So I'm.
And then there was another one here.
Yeah,
I can't remember the judge.
Welch.
Right,
you know,
right.
I wasn't counting the ones where you were second seating another. You were like second seating a more junior attorney, but I do remember one in which the 2 of you prosecutors beat me up pretty good. It was here in this courtroom. I had made a mistake and opened the door to something, and it was Mr. Gubitosi's fault because all of a sudden that sidebar, you hadn't said 2 words during the trial but raised the issue. But in any event, listen, I respect both of you folks. I said on the record, I don't know Ms. Coakley. I don't believe professionally. I think that you may have been the chief of a unit in Middlesex at the same time that I was the chief of the domestic violence unit. I think we may have traveled in the same circles, though that would have been decades ago. But I don't think that you ever appeared before me. I don't think we ever had cases against each other. Again, I respect you as much as I know you, and in any event, I think that that's full disclosure. I'll also just say, as for Dr. Zeisel, you said Dr. Zeisel is not going to do
Correct.
Okay. So, because I think I already mentioned it, he was someone that I used often when I was in practice. So, but it's been years since I've seen him. All right. So, is that sufficient? Did I address? All right. And the bottom line is, I am confident that I can be fair and impartial. I would not accept the waiver, frankly, if I thought that there was some risk that some favoritism would potentially come into play, or if I thought that I couldn't divorce myself from information that may not be admitted at the trial. Okay, so I'm very good at compartmentalizing. I will only consider evidence that's admitted at the trial. All right, and then we'll talk about mechanics and all that afterwards. But let's go through the colloquy. I'd like to, before we have the colloquy, can I see counsel and Ms. Fitzsimmons and Sapphire? and needs, and I'll come right back out and we'll go to the call week and get the folks out of it. All right, thank you.
All rise, please.
Ms. Fitzsimmons ready to proceed with the colloquy of the waiver?
Yes, she is.
All right. Why don't you folks, why doesn't she take the witness stand? And we can pull a chair over for you, Ms. Attorney Coakley, if you'd like.
I can stand.
Please.
Ms. Fitzsimmons, could you raise your right hand? Do you solemnly swear to make true answers to such questions put by the court or upon its directions that will be done?
Okay. Good afternoon. You can have a seat.
Good afternoon, Your Honor.
You can put yourself right up to that mic. So as you know, I'm Jeff Karp, and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. I need to just ask you some questions to make sure that you understand the right that you're giving up and that you're doing it voluntarily, okay? And then you know what the consequences are. Now, so I'm going to have a lot of questions for you. If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Coakley, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you. Yeah, okay? All right, so the first thing I'd like to do is, where's the indictment, Mr. Boyne? I can grab that. So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that, have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay, and do you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. Attorney Coakley, either you or Attorney Bradle have gone over the elements of the charge with Ms. Fitzsimmons?
Yes, Your Honor, we have.
Okay. All right, so I need to just ask you some background questions, get some background information. Some of this I already know, but I still need to, I need to ask you formally. So if you could state your full name.
Kelsey Erin Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth?
11/18, November 18.
And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I did
half of law school? That's enough. Was that enough for you?
No, I'm gonna go back.
You're thinking about going back?
Yeah.
And you said you got a bachelor's degree in what?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No, where did you get the
I'm
bachelor's
sorry.
degree?
I'm nervous, I'm sorry. Fisher College in Boston.
Okay, all right, and totally understandable that you're nervous. All right, and again, some of this I know, but I have to ask, what are you can't be presently working, right? You're not working now.
No, you're
All right, and your last job was with?
Patrol officer with the North Andover Police Department.
Okay, and how long were you there, roughly?
About a year and a half, if you count the academy.
Okay, so you went to the police academy, and
yes.
Then okay, what else? And just normal job duties as a patrol officer in North Andover.
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay. All right. And did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay. And what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
okay,
hydroxine,
okay,
and lorazepam.
All right. And do any of those medications, or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. Did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health condition?
Yeah.
Okay.
Yes.
Do you feel as though that you're suffering from any mental health condition today? In other words, that like right now as we're going through this, that you're feeling some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed in open court with the attorneys about, up to this point, about even like the motion to admit the text messages? Have you understood all of that?
Yes, Your Honor.
Okay. So I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during a jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you were are guilty beyond a reasonable doubt. All right? You understand that?
Yes, Your Honor.
And at a jury trial, you have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting the jurors, and you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
All right. And also, you could choose to have a trial by a judge instead of a jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
Do you understand that by waiving your right to a jury trial, the judge will be me? I will be deciding whether the Commonwealth has proven the charges. Do you understand that?
Yes, Your Honor.
Okay. And you understand that by waiving or giving up your right to a trial by a jury, that I just already told you that. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about the difference between those two types of trial?
I do not.
Now, I'll just hand you this. And I'm showing you a form called a defendant's waiver of jury trial and consent to trial by a judge. Did you read that form?
I did.
Did you discuss it with counsel or the attorneys?
I did.
And did you sign that form?
I did sign it.
And do you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay, did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right?
Yes.
And do you now willingly and voluntarily waive your right to have a jury decide your case instead to choose? You think that I have never done this before. Maybe I'm the one that's nervous.
I'm nervous.
Let me start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, that being me, decide if you're guilty or not?
Yes.
Okay. And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
All right. And the defense, any additional questions that I should pose? Commonwealth?
No, thank you.
None? Okay. All right. Does the defense or the Commonwealth know of any reason I should not accept the waiver?
No.
No, Your Honor. Okay. All right. You may step down. Thank you very much.
Thank you, Your Honor.
All right. I'm going to make the following findings. Yeah, no, Mr. Royan can take that. Thank you. So I'll make the following findings. I find that the defendant, while she is presently or has taken medication, prescription medication in the last 24 hours, I find that that medication has not affected her ability to understand and participate fully today. I also find that although the defendant, Ms. Fitzsimmons, has reported that, or at least I don't know if she reported it, but I do know that at least in the past, she's suffered from mental health conditions, and that perhaps some of that medication is related to that. I do find that any mental health condition that Ms. Fitzsimmons may have had or has not affected her ability to understand and participate fully in the proceedings here today. I further find that Ms. Fitzsimmons understands the nature of the charge against her and the consequences of waiving her right to a jury trial. I find that the decision to, strike that, I find that Ms. Fitzsimmons' decision to waive her right to a jury trial is made with the advice of competent counsel. And finally, I find that the defendant's waiver of her right to a jury trial has been made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge and understanding of its consequences. And accordingly, I accept Ms. Fitzsimmons' waiver of her right to a jury trial. All right. With that in mind, so we'll, anything you folks want to go over, but I anticipate we'll just start on Monday morning. Are you prepared to? Because maybe you're not, with, given that I had said that.
Sure, I hope to be. I mean, that wasn't the plan for all our witnesses, but we'll reach out today and make sure,
okay,
or ensure everybody that we can have is available Monday.
Okay. All right. And so let me say this. I realize that from both sides' perspective that, trying a case, whether it's jury or not, is like trying to, it's difficult herding all your witnesses together. I usually try to make a joke about it. It's like herding fish or something, but Mr. Kubitosi's heard that probably 300 times. But in all seriousness, we will, Mr. Rowan, we're going to go full days. And to the extent that you folks, you run out of witnesses on a day, that's just life, that's fine. Do you expect now with this new, let me ask, with the new kind of schedule where the trial is, the actual evidence in trial is going to start earlier, do you expect any witness availability issues?
Well, everybody was free for the week, so no. I mean, I don't anticipate whether somebody is available Monday in particular.
Okay.
We'll find out.
All right. So it is my anticipation that whatever the, however we proceed, that the trial will be over by Friday. Is that a good, fair schedule or fair belief that I hold, I guess?
Yes, so.
Okay. Okay, so we'll just start up on Monday morning, all right? I will see you folks there.
I'm sorry, I just wanted to point up something for you that you were talking earlier about jury instructions and instructions that you would take into account yourself. And there's one slight, maybe a curveball. There's a Code of Massachusetts regulations. I just want to give you the citation. It's 555 CMR 6.05 parentheses 3 close parentheses.
All right. So let me say this. I don't know exactly what you're referring to, but maybe it makes sense for me to just explain. So what I will ask is that you folks submit. They can be in the form of jury instructions, but just instructions that I will use when I deliver as to the law of assault by means of a dangerous weapon. So whatever it is that you're referring to, Mr. Brady, you should just put in that document again, whether it's however you want to title it is fine, but
it's from the post-commission regulations, Judge, and it's a CMR that states that an officer is not permitted to use deadly force to someone who is a danger only to themselves, and that's really the central issue in the case.
Right, but again, without having it in front of me, what does that have to do with whether the Commonwealth will be able to prove that the allegation is that Ms. Fitzsimmons committed the assault by means of a dangerous weapon. So I'm not following.
I think it has sort of a general import where if the court has a reasonable doubt as to whether or not Ms. Fitzsimmons was engaging in conduct that was harmful only to herself, it does not, by law, excuse the Officer Noonan shooting her.
Frankly,
I'll spell it out.
I don't understand, but
I'll spell it out.
So let me just hold on one second, Mr. Brady. What I expect is that perhaps at the end of the evidence and even before closings, we'll have a charge conference. We'll treat it just like we would in a jury trial, and you folks can make your pitch on the law. But I will want some submissions on the law that I should be. Again, as it relates to the charge and the elements and things of that nature, if there's some defense that you're asserting related to that, you can, perhaps that would be a mechanism for raising that. All right, but right now I don't understand it, and I'm not sure that I need to at this point. All right, and anything else?
Your Honor, do you start at 9 a.m.?
Yes, I'd like to. We do our best to start at 9. Mr. Wayne and I are always ready. But
I know Mr. Wayne is up early.
But Mr. Wayne and I are seem to be the only ones that are ready at 9. But, yeah.
And just folks, 9 to 4 is a full day for the court. I'm just okay. Thank you.
It is. And like I say, if you folks can disclose to one another what witnesses you think you're going to be calling on a given day, and that would be.
And with your permission, I think we should be able to pre-mark a number of exhibits. Okay.
So you'll work that out with Mr. Wayne. That would be great. Also, if we need to take a defense witness out of order, I certainly would hear the Commonwealth if there's an opposition to that. But even for a jury trial, I typically would allow that. Again, if it's a scheduling related matter, not a strategy related decision, but if there's some scheduling conflict, that will help to proceed. All right, so we will see you folks Monday morning. Thank you.
Thank you, Your Honor.
All rise, please.
How many,
Please step out, folks.
Sorry. All right, squad, there we have it. It sounds like it's going to be a bench trial, which should be pretty interesting. It will be faster. There are no openings and closings and stuff like that, because that stuff is for the benefit of the jury. And also, we won't have to, the jury won't have to come and go. It's going to go faster. It was initially scheduled for 3 days, but maximum 5. Curious to see. I doubt it's going to take that long, although I think everybody's a little concerned about, making sure they have enough witnesses scheduled for Monday, sounds like. So very interesting. Personally, I think it's a pretty smart decision on the part of Kelsey Fitzsimmons and her defense to let this judge make the decision. Judge Karp appears to be a very fair judge. If he's very careful about procedural stuff. His career is mostly in criminal defense. So interesting that he has that perspective coming into this. So yeah, interesting. I think it's good news for Kelsey. So we did do a segment on this case last night over on True Crime Squad. I'm going to upload that here for this playlist here on trials, so that if you didn't see that, or if you want to go re-review it, just kind of the basics of the case, you can do that. And we will be back here, and yes, guys, 9 a.m. Eastern, 7 a.m. Mountain on Monday morning. And let's see where this goes. I feel pretty optimistic about it. Yes, that's my ZZ. She is my safety and security officer in this house, and she spends a lot of her life looking out the window to see if there's anything she needs to defend us from. Not that she'd actually go out there and do it, but from in here, she is very tough. So thanks for joining me. Thanks for your patience. It's here very early because I wasn't sure what time we were going to start. But hey, that is okay. Oh, it's ZZ, 2 Z's, like ZZ Top. ZZ is her name. Anyway, I am excited to be doing trials this way, and I look forward to doing many more. So we will see you over on True Crime Squad tonight at 6 p.m. Mountain for case updates, and then at 7:15 Mountain for the watch party. If you want to be able to join the watch party, you go to truecrimesquad.com and become a member of the Super Squad. That helps us, keeps us getting the lights on and all that jazz. And also you get extra content and the watch party and stuff like that. So go check that out. And I will be back with you tonight. Thanks for joining. Have a great day.